Good morning, everyone. Today is October the 7th. Saturday. It's Saturday, I know that. 2017. Okay, if you need to contact me, my email is rick0327@me.com. All right, so, I've been saying for a long time that these support orders are void. I've always maintained that, and, my approach is to prove that these are void. And, how do I go about doing that? Well, I have you guys reaching out to the clerk's office to see if a money judgment lien court order was entered. It's not. Okay? So that's proof right there. Because a void judgment is not going to be entered. Because what are we basing the void judgment on? Well, 90% of these support orders are signed by one of these non-judicial persons, okay? Quorum non-judice. And they're getting away with it because the courts are protecting them, other courts. Myself, I had a hearing with my pension system, and it was an administrative hearing. And the hearing officer was a retired New York State judge, and I'm going up against the pension lawyer. And let me tell you, let's put it this way, I didn't prevail. They fought me tooth and nail because they did a tag team on me. And I was telling the judge, it's not signed by anybody, that's signed by a judge. And he was just playing stupid. And after a while, he was placating me and gave me the old, are you available in 30 days? Oh yeah. And that 30 days never came. It never happened. It happened 30 months later, before another retired judge. So they're all in on it. You would think it'd be very simple to just say, look, it's not signed by a judge. It's and then in New York State, it says under the Family Court Act 439 that support magistrates' orders without a judge confirmation has no legal force. You can't get any simpler than that. And yet, I still ran up against. I still couldn't get it vacated until that the video footage of me in the court, and even then, he fought me. All right, so this is not easy stuff. That's why the best thing that we can do is amass evidence. Reaching out to your employer. Here's another thing. A lot of you, I get it all the time. You get responses from your employer, and they play dumb. Well, we have to follow the order. Now, when you get that letter, please, I had a guy, a new subscriber, reach out to me, and by email, talking about he used the Writ of Mandamus in the past, and he says he was pleasantly surprised by how easy it was, because he was dealing with a corporation, and the corporation was not. Basically, the corporation wasn't following the laws, and he was asking for something, and what he did was he went to the court, filed a writ of certiorari, and I'm assuming, because this is the right way to go, and the judge ordered the corporation to provide the paperwork that he asked for. When they couldn't, the judge found for him. So that's what we're trying to do. So by filing a writ of certiorari, writ of mandamus, writ of prohibition, to get your employer to provide the court order that they're claiming that they're bound by. Now, we know all they have is an income withholding order. Okay, so how is it? Well, we know the judges, they're crooked, but it's going to be difficult for the judge. Plus, when you're there, hopefully, to be in court, you want to have a hearing. So if you want a hearing, what you got to do is, right when you file the paperwork. Come on, lady. When you file the paperwork, you should ask the people in the clerk's office. I want to schedule a date for the hearing. Look it up. Like in New York, it's usually 25 days. They give you 25 days because they give you 5 days time to serve the other party, and then you could schedule it in 20 days. So you just pick a date. Usually it's at 9 p.m. Okay, so look it up in your area. There's the court rules. Even just pick up the phone and call the clerk's office. I mean, you're better off sometimes just by doing that by the phone. Just play nice. Yeah, I'd like to file. And don't ever mention it's for child support. All right. Don't ever tell these people you're doing stuff for child support. Try to hold on to that information for as long as you can, because we know that they got all these people convinced that we're shitbirds, because we're supposedly deadbeat dads. So right away, we're deemed, bad people. That thing I showed you in my video where the guy is filing the writ of mandamus in the dismissal. The attorney wrote, this is like the little wise ass comment. He's using this to avoid his child support payments. Okay, now that's a conclusive statement that this lawyer has absolutely no knowledge of. All he's doing is saying the order is, he's looking to have a writ of. He's asking for the judge's oath of office. You want to see proof that he's is authorized to sit where he is, because he's obviously, this guy's going to be making a decision that's going to affect his life. He's going to issue a judgment that this guy's life, liberty, and property is going to be affected by. So you have every right to do this, and they're fighting us on it. Okay, so the writ of mandamus is a nice tool. I've been telling you about guys this for a while. So like right away, when you guys get this response from your employer, go right away and look into doing the writ of mandamus. Get your employer into the court and provide evidence of a court order. Okay, and lastly, we're focusing now on the writ of habeas corpus. Now, the writ of habeas corpus routinely is used to get people out of jail or prison who have been, has their liberty restrained by some unconstitutional act, or the court order was achieved by some unconstitutional act, unlawful act, anything that is unlawful, or your due process was violated along the way to you having your liberty taken away from you, is what writ of habeas corpus is for. But it's not just for that. You can use it if you're being restrained. Okay, if you're being restrained, remember we learned this word the other day. Your property dispossessed by a void order. That is writ of habeas corpus is another remedy. It's called the Great Writ, and it's taken seriously. Okay? And we were talking about the full faith and credit. Again, the full faith and credit Article 4 is a very strong, it's very good for us, Article 4 of the United States Constitution, because it deals with state rights. Okay, so routinely we're always dealing with these courts, and whenever we mention any type of federal statute, anything, we get the usual, well, it's a state court and we don't do it. They do that all the time. Okay, but Article 4 deals specifically with state rights in the Constitution, meaning that, just because you have one law in a different state, they're usually, they're supposed to be uniform. So it's, the states are supposed to honor another judgment or another act, another public act. Okay? It just might be under a different name or a different code. Okay? Urinating in the street is unlawful in any state. It just might be under a different code. Okay? So, I'm using that as an example, but because urinating in public is is not good in anywhere. Okay? So, you don't have to know the law. You just know that it's unlawful. It's unlawful in the states for a judgment that's not signed by a judicial officer. Remember, we're using 28 U.S.C. 1691 on that, okay? All of our judgments are supposed to be signed by a judicial officer, usually a clerk, not a deputy clerk. Remember, we were talking about this stuff a long time ago. Well, and like in New York State, I have a law. It's CPLR 5016 is a mirror image of that, basically. In your state too, I guarantee it, if you do a little digging. All right? So it's important that we cite the Article 4 in our paperwork. I just started doing that, updated my paperwork with this stuff. Also, we're able now to use the full faith and credit. We could take a case law like, Richie Cole sent me a nice email with all the void judgment cases. So you could take all of these case laws from different states saying that a void judgment can be attacked at any time. So you don't have to just look for that for an opinion that comes from your state. It would be nice if you could find that. Okay, I like to try and find case laws from my state. Okay, just to try to avoid this, to avoid any trickery. But now that we have the full faith and credit, we can cite that and use that to say that, under the Article 4, Section 1, full faith and credit, the state must honor a decision from another court of competent jurisdiction. Okay, so and that's why we're looking to do we use the new topic, the new remedy that I'm focused on these days is the writ of habeas corpus, the Great Writ, and it's supposed to take precedence over everything, because we're dealing with somebody who's claiming his or her rights are being restrained. So you go to the front of the line. You're supposed to. So if you go to the court and you file it, you're supposed to go to the front of the line. Okay? And it's a petition. So you make yourself the petitioner, you make the court, and whoever signed the judgment, the respondent. Okay? And that way, a guy yesterday went to court, and these freaking clerks there. This is, I get a lot of emails because these clerks, well, what do I do? And, hey guys, I'm not there with you. I can only tell you what, you guys got to fight. You got to learn this stuff. Okay? I could tell you stuff by an email, but I'm not there with you. Listen, I had plenty of fights with these people. That's the reason why now, whenever I don't have to go anymore, thank God. But when I was going, they treated me with kid gloves because they became afraid of me, because because I showed them that I knew what I was doing, and also I made enough noise. I sending out letters to the chief judge of the state, posting videos on YouTube. So, I became a thorn in their side. You could become a thorn in their side. Federal Rule 5, look it up, 5B. The clerk's office is supposed to accept all pleadings. Okay? You cannot be turned away over some bullshit procedure, because they want you to use their paperwork. They only want you to fill out their 4 lines. You ever look at that paperwork? That's the reason why it's like that. They don't want you to give too much details. They want to be able to turn you away. But what you could do is use that cover page, and whenever whatever line, you just say, "See attached affidavit." Then you attach your the affidavit. Maybe you take off the cover page, or you submit the whole thing, all right? And you submit that as an affidavit, and you put down, where it says line, whatever, say, please describe what you're looking to do, whatever. You just write, "See attached affidavit," okay? And that's what you do. Because that's what these lawyers do. That's how I learned this stuff. I learned it by doing the research, okay? And I'm going to do a video. Listen, I know everybody got that form letter in the mail from the Department of Health and Human Services. What a coincidence. We all got the same letter, and it was all dated the same date. Why do you think that is? And it took them 5 months to get back to us, because they didn't know what to do. Okay? So obviously we were on the right track. Okay? Well, that's something else to deal with. I feel that right now the way to go is, if you have a void judgment as your support order, the way to go is the writ of habeas corpus. Still go after your employer. Okay? Your employer should be afraid of you, because they don't have a leg to stand on. They really don't. They don't have an order to take your money. So if you go to do this writ of mandamus, certiorari and a writ of prohibition, if you do it the right way, you could get all your money back, because they never had a leg to stand on. So if they cannot produce a valid court order, Your Honor, I want all of my property reimbursed. Or you write it in your order as part of your relief. Restoration of property seized without cause. Your property can only be taken by a warrant. That hasn't changed. Okay? They just been getting away with it because everybody in the courts, they're all conspiring together. They all stick up for each other. That's a strong gang. These people really stick up for each other. It's sadly for us. All right, so that's it. I'm going to shut this video down. Hopefully I got through here. Look up writ of habeas corpus. I'm using the writ of habeas corpus for a void judgment, quorum non judice. There's a good case law, New York State Court of Appeals, our highest court in New York State. It's called People versus Schildhaus. Schildhaus. Look it up, and that's a good case law that you could use now, thanks to using the full faith and credit clause of the United States Constitution. And the reason why they did that, and I know I'm jumping around, but because it's hitting me, is because they don't want you to go through a full, they don't want the court to be bogged down by this. So by you citing that precedent, it could say, well, all right, yeah, it's not signed by it's a non-judicial proceeding. That's really what it is. It's a non-judicial proceeding. Any non-judicial proceeding is lacking jurisdiction. Okay? And that's it. It's void. Any court that lacks jurisdiction, any judgment coming from that court is void. Okay? And that's the reason why we're allowed to use these judgments from different courts. All right? So listen, enjoy the rest of your Saturday. I'll talk to you guys later.